Well, a couple of places for greeting cards in Canada are closing. The U.S.-based parent company of Carlton Cards and Papyrus is closing all of its stores in North America. This is the latest in a series of Canadian retail closures. So we wondered this morning, what happens to the employees and what are they entitled to when it comes to a settlement? Alex Lucifero of Samfiru Tumarkin LLP is with us. Good morning, good to see you.
Morning, Leslie.
Let's talk about that. I mean,
Sure.
they're learning that their jobs are now gone, they're closed, the company isn't necessarily in financial order, this was just a business decision. What are their rights?
So obviously a difficult situation, Leslie. For the company itself, it's obviously decided that operations are not profitable, so they're going to shut down. But I think it's the employees of the company that will bear the biggest brunt here of this decision, in the sense that they're losing their jobs.
Yeah.
And that's obviously a very difficult situation, maybe one of the most difficult situations a person could face in their lives. The good news, I guess the sliver of good news in a situation like this, is that these employees are owed severance. It doesn't matter that the company's closing down. They're not going into bankruptcy. They're not going into receivership. And so they're owed severance. Hopefully that severance can hold them over until they can find another job and move on.
This is not a Sears debacle where the company went bankrupt and those poor employees lost everything, right?
Probably the worst example of a major retailer closing was Sears. They did go into bankruptcy, Leslie, so that was a very different situation. This situation is more akin to, let's say, the closure of the Future Shop stores that happened 4 or 5 years ago. Now, those employees were certainly owed severance, just as these employees are owed severance. It's a very, very precarious situation to be in as an employee, so they've got to be on high alert.
So common thought is that you are entitled to 1 week for every year you've worked. Is that, you're looking at me like you've heard this before?
Common misconception probably is the best way to put it. Leslie, that is far from the truth. The law will look at a number of factors in order to determine severance. Those factors, the main factors at least, are age, position, years of service with the company. The older you are, the more senior your employment, the longer you've been with the same company, the more severance you're going to get. It's not going to be a week or two of severance, Leslie. It's probably going to be much, much more than that. The word of advice that I would give to employees at this point of Carlton Cards and of Papyrus is don't sign anything on the spot. If you receive a termination letter, if you receive some sort of severance offer, take that home with you. Get professional advice from an employment lawyer. It doesn't have to be me, but as long as you speak with an employment lawyer, you need to assess whether that offer is reasonable or not.
Let's go big picture, because a lot of people saying, wait, this happened in my company. If they say, well, if you don't sign now, you're not going to get what we're offering you, what do you say to them? And what do they say to the bosses?
It's an intimidation tactic from the company. Hopefully, as an employee, you've got the strength and the fortitude to say, I'm just going to take this home. There is no law or rule or principle out there, Leslie, that says that you have to sign on the spot or within 2 days or 3 days or 1 week's time. There is no such rule. So you've got plenty of time to get advice. Don't feel pressured by the company. You need to make sure that this is a fair shake for an employee.
Interesting choice of words, an intimidation factor
Tactic,
there.
let's say, yeah.
That's the word.
Yeah.
Is that a defense if you've signed it and you say, oops, I've signed off, can you go back?
It's very, very difficult. It can be a defense, but it has to be very, very obvious that it was an intimidation tactic and you effectively were coerced into signing. So in this situation where you are told to sign on the spot and you're not even given a chance maybe to read the document properly, that might be coercion and that might be unenforceable. We might be able to get around that. Again, very difficult situation. You want to avoid signing on the spot at all costs.
Is there a statute of limitations? If somebody's watching this happened to them 2 years ago, can they go back?
There is. It's 2 years. So
Okay.
you've got 2 years from the date that you've been given notice of your termination to deal with this. You don't want to wait 2 years, Leslie. You want to jump on this right away.
Yeah.
Again, the deadline doesn't ultimately matter, but you do want to get advice in a situation like this as quickly as possible. We see lots of severance packages in our line of work. A lot of them are deficient. A lot of them are not what an employee is actually owed. So again, an employee has to be on high alert in a situation like this. You need to make sure you're getting a fair shake, and the way you do that is by getting advice from an employment lawyer to make sure that severance is fair.
Is there always severance for someone, regardless of the reason for dismissal?
In a situation like this, there is always severance for someone. There may not be severance if an employee is terminated for cause, or what's called just cause. An employee has to do something really, really egregious and really, really kind of serious misconduct in order for there to be cause for termination. This is not going to be an example of one of those cases. These people are obviously being restructured out of their job because the company's closing.
Thank you, sir. Always a pleasure. Thank you for your free legal advice this morning.
Thanks for having me.
All right, Alex.